Hi, everybody. Welcome back to the Leader Living Life podcast. We've got two great guests with us today. We're going to talk about some really current and interesting issues, at least interesting to me, around the legal environment and the impacts of COVID-19 on two particular topics. The first we'll talk about is contracts, and the second will be around employment. And we'll talk about it both from an employer and employee side. So joining us first is Sarah Sawyer. Sarah, would you introduce yourself?
Hi, thank you so much for having me. My name is Sarah Sawyer. I'm an attorney with Offit Kurman. I'm in our labor and employment group, and I work out of our Baltimore office. Right now I work out of my home office in Baltimore, in Hamden, with my dog, Alfie, and my husband and two cats. So a little bit of a different office environment, but my background is in labor and employment. So lately, especially in COVID-19, been spending a lot of time advising clients on how to weather the storm and how to handle different employment issues arising from laying off their workforce, bringing them back, employees that are dealing with employment issues. So thank you so much for having me.
Awesome. Thank you. And we also have with us Jonathan Wachs. John, would you introduce yourself?
Sure. Hi, I am Jon Wachs. I am also a lawyer with Offit Kurman. I am a bit of a journeyman. I've practiced in a number of different practice areas. I do business transactions, I do general corporate work, and I do intellectual property. I live here with my wife outside Baltimore and our two kids. We have a freshman in college and a freshman in high school, and we have a 4-year-old Golden who I believe to be everyone's favorite member of the house.
You've been outvoted by the dog.
Yeah, for sure.
John, could you do us a favor and kind of lay down a couple of ground rules before we get started into the topics, particularly around the fact that these are legal in nature?
Sure. So, as is the case with most legal presentations, we have to provide a preliminary disclaimer, which says that what we're going to say today is intended not as specific legal advice, but as general food for thought, general legal issues to be considered. If anybody has any specific legal questions about how what we have said might impact them, feel free to contact either Sarah or me, and we'll help you if we can, or we'll help direct you to somebody else if we can't. Many of the issues that we handle are governed by specific state laws. So Offit Kurman is a law firm of 250 attorneys from New York to North Carolina. We have good coverage in many of the states, but certainly not all of the states. And if you're listening to us from an area outside our area, we'll help point you in the right direction.
That's awesome. Thank you. And I'll put a link into the firm's website when we publish the podcast, so folks don't have to figure out how to write that down, and just look at the notes from the podcast, and you'll be able to link right into that. So, John, let's kick off with contracts.
Sure.
So I'm displaying some slides that are from John, and I had seen them earlier in the month, and I thought they were really good. So with that, John, before I get into questions, do you want to kind of walk us through this presentation?
Well, there are people in my firm who are handling COVID-19 specific issues relating to getting a PPP loan and how do I get the money and how do I keep the money, and that's not what I want to talk about today. There are others at my firm who address those issues more squarely than I do. The questions that I'm getting are from business owners and business operators saying, now that COVID-19 has hit, what do I do with my contracts? Are my contracts enforceable? Are they modified? Are they unenforceable? Are the obligations terminated? Are they deferred? What do I do? Most of us are in the business of operating businesses, growing businesses, and you sign contracts, but the contracts have meaning. And when you're in unusual circumstances, you have to turn to those contracts to figure out what needs to be done and what can be done and what can't be done. So I normally start this discussion with a basic question: what is a contract? And not everyone has the same understanding. Eric, what do you think is a workable definition of a contract?
Um, so this will be a complete layman's perspective, but generally I focus on some type of written agreement that is mutually agreed upon and executed. But we've had situations where it's not a physical document, but there's still an obligation, or at least something you have to defend as being or not being an obligation.
Right. So, you mentioned that a contract needs to be in writing. Some contracts need to be in writing, others don't. There are things such as oral contracts. But in order for a contract to be a contract, it needs to be a legally enforceable exchange of promises. And that's all you need. That is a workable definition. So I have to promise you something, and you have to promise me something. And it has to be legally enforceable. So if I promise something to my dog, and he doesn't promise me anything in return, that is not a legally enforceable exchange of promises. First of all, you normally need to be a human in order to have an enforceable promise, and you need to be over the age of 18. So on the assumption that I have promised you something and you have promised me something, I'm not promising you something that I've already required to do, we're going to call it a contract. Most people think that when a contract has been signed, that's it. You have to live by the contract, and there's no way to get out of it. But actually, there are several ways that one party can avoid performing its obligations under a contract. And the one that's getting all the discussion right now is force majeure. Force majeure is a French term for force of nature. And it says in the contract, if situations X, Y, and Z occur, then each party either can terminate his obligations or suspend during the force majeure event his obligations. But that's only one of several different ways that one party can avoid performing his or her obligations under the contract. So I'll take a few minutes and go through that. But it's important to know that just because you promised to do something in the contract, or the other person promised to do something in the contract, that doesn't mean it actually needs to be done under all circumstances. So what people are trying to understand is whether or not COVID-19 is a force majeure event that will help people to ignore contracts or modify contracts. And force majeure is very fact specific. It really turns on the specific language of the contract. And the force majeure will say, in the event of fire, flood, earthquake, then the party that has suffered the loss that cannot perform either won't have to perform or can delay his performance for so long as that force majeure event continues. Well, in everyone's laundry list of force majeure events, nobody includes pandemics. Pandemics have not been included in force majeure contracts because up until now, that was not a serious anticipated threat. So some people are saying, well, if you list 6 other natural disaster events and you don't list pandemics, then it is presumed to be not a force majeure event because it could have been anticipated and it wasn't. Other people are saying, well, if you have general act of God language, a force majeure event like COVID-19 is an act of God. So those discussions haven't worked their way through the court yet. So we don't really know whether or not there will be a blanket understanding that a pandemic is an act of God, which will be read into force majeure paragraphs. But let's say that there is no force majeure paragraph in a contract, or there is a force majeure paragraph, but it doesn't specifically mention pandemics. And that's the case with most instances. Regardless of the force majeure, there are other defenses to obligations under a contract. Can we go back one, Eric? I was still on slide. Yeah. So in the event that during COVID-19, one party breaches, stops making payment, or stops providing goods or services, the non-breaching party could say, you breached, you stopped, you broke your end of the bargain.
Right.
And therefore, that could be a claim to say, because you breached, I no longer need to perform. So that is another basis for saying, I'm not performing because you didn't perform. Another issue is impossibility. So that's the case where if I have a contract with you to rent your house and the house burns down, it is impossible for you to deliver that house to me.
Right.
Therefore, you don't have to perform. An interpretation of impossibility is impracticality, where we say that if you are to sell your goods to me, and as a result of COVID-19, the costs of you performing have escalated. So it's now triple, quadruple, quintuple.
Mm-hmm.
It's not literally impossible, but it's impractical. You would never honor that contract on the same terms if you knew that your pricing structure is what it is. Frustration of purpose is that, if we have a contract for you to provide goods or services for an anticipated event and the event is canceled, then, that contract no longer has any meaning. Yes, you could perform, but you wouldn't perform because that event is no longer the reason for the contract. And illegality is a case where it is unenforceable because the parties are seeking to enforce an arrangement that is by its nature illegal. So let's take a hypothetical situation from Baltimore, because that's where Sarah's sitting. And we have a contract for US Foods, a Maryland company that provides food, to deliver 1,000 cases of hot dogs to Camden Yards. And you don't need to modify the hypothetical situation very much in order to try to invoke each of these different defenses. So Camden Yards, stops its payment for the hot dogs, and US Foods is going to say, well, we're not delivering the hot dogs because you're no longer paying us. That would be a breach defense. Force majeure would be if the contract itself said, in the event of an act of God or in the event of a pandemic, we don't need to provide you with hot dogs. You would invoke force majeure and not provide it. Impossibility would be if, as a result of unforeseen circumstances, Camden Yards burns down. It would be impossible to provide the stadium with all the hot dogs it needs for the games this June. Frustration of purpose, if the Orioles continue to not play, the Orioles would say, we're not going to honor this contract because we don't need the hot dogs, we're not having games. And while Governor Hogan has said that no public events may be held, it would be illegal for the games to be conducted, and therefore it's an illegal contract which cannot be enforced. So, as people are going through their library of contracts in their drawer, you should think not only about force majeure, but all of these other potential defenses to see which ones can you use and which ones can be used against you. And once you understand who's holding the cards, you can figure out whether and to what extent you want to modify your contracts. So that's a long explanation for a background slide, but I think it's important to sort of set the table that way.
Yeah, that was really helpful, actually.
Sure. So now we can go on and talk a little bit more in depth about force majeure. And this, as I was saying before, is really language specific, really contract specific. We look at the terms of the contract to see whether or not one party's performance will be excused. And if there is a force majeure event, one party's, first of all, it could be mutual or it could be one-sided. It could excuse the performance altogether, or it could only delay the performance, or it could modify the performance. So you really need to sort of wordsmith a force majeure clause to see whether a force majeure event has occurred. If it has occurred, does it affect one party or both parties? And how is the obligation modified? If you have something, you're not necessarily going to find clear language as it relates to pandemics. You know, we've looked at the cases, and there are some cases relating to pandemics as it relates to agricultural supplies back in, when was the Asian flu? About 10 years ago. These contracts are case specific, and you're looking at case law that is jurisdiction specific. So you'll have to think about how cases in your jurisdiction have interpreted analogous circumstances. And that's why lawyers get paid, because they'll say, you know, this fact pattern is more analogous to bird flu than it is to a warehouse burning down or something. I would imagine that, you know, 2 or 3 years from now, we'll have dozens or hundreds of cases interpreting contracts as a result of COVID-19, but we're not there yet. We can move on now to
I have to admit here, 30 years of professional experience, I cannot tell you how many times I've been relatively dismissive of this part of T's and C's in an agreement.
Right.
It kind of, number one, I did not understand that there was a specificity about that clause on the types of events. You know, I think, and I don't think I'm alone on this. I think a lot of people think that the term force majeure carries a whole bunch of stuff built into it, and
yeah, for sure.
not the understanding about the fact that there have to be very specific explanations in that part of the contract that like I said, we kind of just have blown through that in most contracts as boilerplate is the term everybody, you know, would throw around. Oh, it's just boilerplate. And I bet many people are not thinking that way now.
That is the big
is
takeaway from this whole experience, is that force majeure paragraphs for most of our professional lives, for most of our legal history, has been deemed a non-essential boilerplate provision that is thrown at the end of the contract if it's in there at all, and it really shouldn't be. The more specific it is, the more it's catered to your circumstance, the more enforceable it will be.
Yeah, I think that's a great point.
So a lot of people think about impossibility versus impracticability. And some jurisdictions recognize impossibility, but not impracticability. Some jurisdictions recognize both. So in order for something to be impossible, the contract can literally not be enforced and performed at any price. You know, we're not, and in cases where we're talking about impracticability, you need to show that it's not just a slight increase in prices, but it is a significant increase in financial commitments or time commitments or complexity that's far beyond what the parties had anticipated when they signed the contract. So in the case of impossibility as a defense, the subject matter of the contract must be physically destroyed. In impracticability, that's not the case.
Oh, okay.
People routinely use interchangeably the defenses of illegality, impracticability, and frustration of purpose. Don't do that, because the case references are different, the rights of the parties are different, and the chances of success are different. So if you're in a situation where you're trying to enforce or avoid a contract, make sure you know which defense applies and to whom.
Jon, is profitability a consideration in either impossibility or impracticality, meaning that the cost is raised to a point that is it like, what's the breaking point? If it's break even, it's possible, or?
When we talk about increases in obligations, it costs you more, or it takes more time to deliver the same service that you're contractually obligated to perform, that does not relate to impossibility. That does relate to impracticability. There is no bright line test that says, if it increases 40%, you can avoid the contract, but only 30% you still have to perform. It's case by case. Judges decide. But I think a good way to look at it is, if your prices increase, sixfold, I think that's an easier case. If it increases just a little bit, you may or may not win, and that to me means if you don't know whether or not you're going to win, you better negotiate some sort of a contract modification.
Sure.
I think we're done with this one.
All right.
And I think this sort of answers your question a little bit, which is we have a restatement of contracts so that everyone sort of can refer to the same source when trying to understand how contract law works. And for impracticability, these address your issues. So I don't want to read it. People can read it here. But if there's a basic assumption under which the contract was made and that assumption is no longer true, then your ability to modify the performance is discharged. It's not modified, but discharged. So if we assume that you're selling widgets and part of that pricing and part of that delivery chain is the availability to you of widget components from China, and as a result of rules in China, you're no longer allowed to get those component parts. And they've said that there's no other place in the world that can provide substitute parts. I think your obligation to provide the widgets has been discharged.
And can that be a partial part of the contract, or is it the contract in total? So if I have a contract to provide widgets as well as some other service or product that is unaffected, can that one component be discharged from the agreement, but I still have to perform the others?
That is a good question. And there's another boilerplate provision called severability, which is usually in contracts, but not always in contracts. You probably sign contracts with them all the time. But the severability boilerplate provision says that if any one provision of this contract is unenforceable, the rest of the contract shall be enforced. So if you have that provision, which you usually do, then you can enforce some but not all of the contract provisions. If you don't have that provision, then if there's one essential part of the contract that's unenforceable, you can say the entire contract is not enforceable.
Got it.
Okay, so I don't want to steal all the thunder from Sarah, so I'll try and buzz through this a little faster, but sort of takeaways, things to consider, understand where the contract is governed. Each contract should say this is subject to the laws of North Carolina or New York or Maryland or whatever, and different states have different rules regarding defenses to contracts. If you do have a force majeure clause, you really want to understand what it says. Just because things are going to take you more time or more money does not mean you can avoid a contract, does not mean that the other parties cannot avoid the contract. And business closures can give rise to a defense of illegality. So for all of the non-essential businesses, they are not allowed to occupy their property. Hopefully that will all change soon for businesses, but because they were not allowed to operate for a period of time, there is an illegality defense that is available to you and maybe used against you. So think about all those different issues. Then we're at takeaways, Eric, which is the next one. Update your forms. Most people don't have adequate force majeure paragraphs, particularly in their forms. You want to take an inventory of all of your contracts to see what you've already signed, so you understand what your rights and your defenses are and what rights and defenses can be used against you, and plan ahead. Eric, to your point, don't think of all of your boilerplate provisions as things to gloss over. Give them some additional consideration now that we know how they can sort of come back to bite you.
Yeah, I think one example is people have got a lot smarter at looking at their insurance policies.
For sure.
From a business insurance perspective, I'm self-employed at my own company, and got an email from the insurance company saying, "Hey, listen, this is not covered on your force majeure." I hadn't filed a claim, but they were just bringing it up to everybody. There's a lot of push for people to do it under business continuity clauses in their insurance, and it'll be interesting to see the muddy mess that comes out of trying to resolve those policy claims.
Yeah, a lot of these issues are clear as mud.
Yeah, exactly. Well, I think part of the challenge is that in some cases it's abundantly clear in the language.
Mm-hmm.
And who thought that we were going to be in this position? Who thought? And there are examples. Wimbledon is one, who decades ago did an insurance policy that included pandemic.
Right.
And so when they couldn't hold Wimbledon, they were compensated under their policy.
But for every case like that, there are thousands or hundreds of thousands of claims policies that don't have that language. So
yeah, and it was called out as being an oddball. That kind of, they got under the wire with that because they had done it so long ago. But that most policies at this point don't cover that.
Well, I think that it will be harder for people to argue in the future that pandemics cannot be foreseen, because we know that, so if you're signing contracts that don't have a force majeure clause and don't specifically address what will happen in the event of a pandemic, you do so at your own risk.
Yeah, don't
sign
it.
You need to think about those.
Yeah.
So a lot of people may have questions. My contact information is on the last slide. Happy to talk to anyone about any of these issues.
That was awesome, John. I appreciate
Sure.
you taking the time to do that. I learned quite a bit from it, so that was very good. So with that, Sarah, how about we turn over to you for now?
Yeah, hi. That was great, John. Thanks. And, I wanted to just kind of dive into a couple of things on the employment side, both from an employee and an employer situation. Obviously, there's a lot going on here. As you've probably heard, there's a lot of new laws, new regulations. Things are changing frequently, as John put it, with some of the things he was talking about, that some things are just so clear as mud right now when it comes to COVID-19 pandemic policies, and things are changing a lot. So kind of just some things I wanted to dive into are a couple of big questions that I've been getting from both employers and employees. What are businesses required to do to keep employees and customers and clients and folks safe? What happens if someone gets sick? What will the workplace look like for businesses and workers, and for how long? And the impact of the new normal on businesses financially and their ability to reopen and stay open. So, as people are bringing back their workers, some businesses obviously have never closed and have remained open, but they might be bringing back more of their workforce. It's going to look different. So, as I'm sure a lot of listeners have seen just in their trips to the grocery store and around town, no matter where you are, it's probably looked quite different than it did a couple months ago, and businesses are going to look the same way. So, as some office businesses start to reopen that were non-essential, what employees should be looking for and what employers should be doing is really making sure that they're following CDC and occupational safety guidelines and keeping up to date on those. So it's, that's a really important piece. Just making sure that they're modifying their layouts and erecting partitions and plexiglass between employees and customers, posting rules, and encouraging call out if people are sick, wearing masks around common areas, and limiting people congregating in the office, requiring appointments for clients or customers, and implementing new policies to address all of these things. So it's really important that everyone's on the same page about what the expectations are and how the business is going to be keeping people safe, and putting good policies in place for that. So businesses, offices are going to look very different. I mean, I always joke that the time of the communal snack jar is long gone.
Gone.
It probably should have been long gone before this, but it's definitely gone now for the foreseeable future and maybe forever. So, we're all going to treat things much differently. Flu and cold season is going to be much different moving forward, and how people are going to prioritize their health and safety when it comes to germs and things like that. So, really, businesses can't sit on this and wait. They really need to start implementing policies and procedures now as they start to bring employees back. Eric, I know that we had chatted a little bit about, you got some questions around kind of waivers and different things. So
yeah.
A lot of the reason to be taking these kind of precautions and making sure that you're following, that businesses are following CDC guidelines. It's important so that they are keeping their workers safe and are able to remain open and don't have to shut their doors because of a COVID-19 outbreak. But it's also important from a liability standpoint in keeping their employees safe. And so some businesses are exploring waivers and different documents to try to absolve themselves of potential liability. The important thing to consider here is that if you're an employee that's being asked to sign a waiver, or if you are a patron of an establishment or a client that's being asked to sign a waiver or enter at your own risk or things of that nature, even in those waivers, and a company is not going to be able to, and this varies by state, but they're not going to be able to have you waive away gross negligence or intentional conduct. And so what this is going to look like moving forward with regards to this particular circumstance, we don't really know yet. Obviously, this is a very unique situation that we're all dealing with, and we definitely anticipate a lot of lawsuits coming from this, and there being somewhat of a litigation bubble after this, both on an employee side, on a client side, customer side. So businesses are doing what they can to try to limit their exposure, and part of being able to do that can be a waiver, but it's also, they're going to still have to take precautions to make sure that they're not putting people in danger and doing things, intentionally. So it's really an important thing for businesses to do both. They can't just ignore, the safety procedures that they should be putting in place, especially when it comes to employees and having a heightened duty of providing a safe workplace. So, the Occupational Safety and Health Administration, so OSHA, they will be doing inspections and different things, as businesses are reopening. And so there's hopefully going to be things in place that are helping to keep employees safe. And then there's just also the practical standpoint, as I mentioned, of you don't want to have to close your doors. You want to be thinking about this long term. This virus is going to be with us for a while. So it's important to, if you've got an outbreak at your establishment, that's not good on a lot of levels. So, important to keep that going.
Yeah, I think it's going to be interesting as companies push for waivers. If somebody's deemed essential by whatever definition of that is for the company, what's their optionality going to be around signing the waiver? They have to go to work because they're a firefighter, a nurse, whatever. I'm not sure what the whole list is. Mm-hmm. They can sign the waiver, but they're not doing it essentially. They're not in a position to say no unless they're willing to essentially leave their job.
Yeah, there's another thing to consider here is that workers' compensation is likely to cover a lot of potential claims that come out of this. So, there are safeguards in place for employees that if they get sick on the job or they're able to track it back to work, because that's going to be another thing that's going to be problematic for either whether it's employees or whether it's just other types of individuals. So if I go to my local restaurant and I think I got COVID-19 there, and I want to sue them. So there's going to be what we call causation issues. So trying to make sure that you're able to track it back to that actual establishment or to your job. And in some instances, that can be done and it's easier. Like if there's a big outbreak at your job and you have limited exposure out, anywhere else. But then there's going to be a lot of circumstances where it's not that easy to make that connection and hold a company accountable. So, it'll be interesting to see how that's handled moving forward.
Yeah, I get a feeling you're going to be a very busy person in the coming years of dealing with the employee issues around this.
Yeah, so that's and that's why we're spending a lot of time right now really trying to do everything that we can on the front end to help businesses and provide them with guidance on what to do. So for example, what to do when an employee does get sick, right? Or if someone is having symptoms, and putting things in place to say, all right, if you have a fever, you're not going to be able to come into work. You're going to need to quarantine for 14 days unless you get a doctor's note saying otherwise. Erring on the side of caution in those situations. Changing their policies even when it comes to employee leave to encourage people calling out. So some listeners might be familiar with the Families First Act, which went into effect April 1st, which was providing expanded sick leave and FMLA leave for companies under 500 employees. So that was, largely that was back at the beginning of all of this, or towards the beginning of all of this. And that was really aimed at making sure that employees could take off as opposed to coming in sick and spreading the virus. But, just given how this pandemic, COVID-19 is really sticking around, it is fathomable that people might take some of that leave to help care for a family member who had COVID-19, and then they might contract it themselves and may end up having to go unpaid to take off, or if the business has instructed them to quarantine or anything like that. And so to avoid people hiding symptoms and not calling out when they should, employers and businesses may need to consider other options as far as providing additional leave to employees. Really think about those bigger picture aspects.
Yeah, if we were having a leadership conversation, I'd bring up the point that you get the behavior you reward. And if the behavior you're looking to reward is people not coming in when they're sick and jeopardizing customers and coworkers, then that has to be the reward, the behavior that gets rewarded. How you do that, that's going to be a complicated thing. And how do you police it? So there's a lot of work to do there. And I can't help but to go back to one of John's earlier points: update your forms.
Yeah.
It'd be interesting to know how many companies have bought pre-printed forms that none of the content is theirs, essentially. Employment applications, all of these other types of documents. You're going to have to step back. And you're going to have to spend some money. You're going to have to engage an attorney that has that specific discipline mastered to make sure that you're crafting the right forms and policies. And I think there's going to be some relevance to the industry that you're in as well.
That is, it's going to be very specific. I mean, a lot of, especially from a procedural standpoint, and how you're handling where masks should be worn and all that those practical pieces, very industry dependent, depending on if you've got clients and customers coming in all the time, if you don't, all of these pieces. And, you make a great point. It's really, that's a huge piece, is just updating your policies. There's no better time than right now to really take a look at what you've been doing and how to supplement that. What to add to that. I mean, a perfect example is a lot of employers and businesses are going to be doing temperature checks of their employees as they come in every day, and they're going to be keeping logs of those temperatures. Well, it's incredibly important that that information is kept confidential and outside of the employee's personnel file and its own confidential medical file. Well, that's something even before this that I see employers make mistakes on quite frequently is they're keeping medical documentation of their employees inside their personnel file. Well, that's a violation of the ADA. So now is a great time to take a look at your practices and policies and say, all right, well, first of all, we're going to have to add to them temporarily and maybe even permanently, no more communal snack dollars. But, we're going to have to really take a look at these and make sure that we're supplementing them properly and have a clear understanding of what's expected from the employees and what they expect from us.
That's an interesting point. Does the tracking of this somehow bring about the need to be in compliance with HIPAA, or is that limited to the medical type industries?
So you want to make sure that you're complying with all of those regulations. So it's going to depend. There's HIPAA is a complicated aspect of things, but I mean the main piece is that you're keeping these records confidential, and that HIPAA has more to do with disclosure if someone asks you for records and things like that. What I would encourage people to focus on is more like your record keeping and how they're being kept and who's got access to them and those kind of things that help ensure that you're compliant down the road and that you don't accidentally send a medical record off to someone or something.
Right.
But yeah, because even, an interesting thing that I've had a lot of clients bring up to me is that right now it's temperature checks, but next it might be, test actual COVID-19 testing once we have more access to those tests. And it might even be vaccines at one point. It might be, if there's a vaccine, are we requiring employees to get it? And what is that going to look like? And keeping those kind of records. And so while we don't have answers on that yet, given what we know about other types of vaccinations and medical procedures and things like that, employers may be able to require vaccinations with exceptions for health reasons or religious reasons. So temperature checks are probably the tip of the iceberg, so to speak, on things that are to come in the workplace.
Yeah, that's the minor part. Man, I didn't even think about the immunization part. Talk about a hot topic. There's definitely two sides, and they feel adamant about their side. So it's going to be a tricky environment for employers to figure out.
Yeah, well, and just a big piece for businesses, both from an employee standpoint and from clients and customers, is with temperature checks or any of these regulations, is that it's putting businesses really in a place of having a different relationship with their employees and with their clients and customers, because it's not always the most comfortable thing to give a client a questionnaire and say, if you answer any of these questions yes, you're not going to be allowed to enter the building.
Right.
So, and a lot of times the questions are you experiencing any of these symptoms? Have you traveled recently to any, hot spots or zones, where there's a lot of the virus, or have you been in contact with anyone with COVID-19? And having those clients or customers certify that the answer to those questions are no before coming into the building, it puts businesses in a unique position of asking some very personal information of people.
Yeah, it gets uncomfortable when you're pushing on someone who's coming to spend money with you.
Yeah.
We kind of like to get to the spend money part and avoid the pushback part, but it's going to be a reality of how we go forward. Yeah,
it definitely will. And I get a lot of questions. I mean, the $1 million question is for how long is the workplace going to look like this? And, what's it going to look like and what the impact's going to be? And that really, it's changing constantly, but I think that the thing we do know is that it's going to be with us for a while, and that this is not going away. So even though things are changing, you can't wait to put these policies in place. You have to be proactive, and really think these things through for the short and long term, and just be ready to pivot, because it's, you don't want to wait until the moment of absolute clarity, because it's never going to come likely. So you have to do what you can now based on the guidance that you have from your attorney, from other, from the CDC, from, professional organizations, from anyone that you're in touch with, and do what you can with the information that you have and continue to be ready to pivot and adapt. Obviously all of this does come with a cost for businesses as well, but I would argue that the upfront cost of addressing these things, taking the safety measures, and making your workforce, both your employees, your clients, your customers, making them all feel safe and that you're taking it seriously is a better cost than the potential liability on the back end of not complying with things, or having an outbreak or having those issues.
Yeah, absolutely. I had on the I had the CEO of Risk Connect on for an earlier episode, and he described this in an interesting way. So they specialize in providing solutions for companies to manage risk across all kinds of domains, and they're talking to their clients about the fact that this is episodic. There's going to be these highs and lows. This isn't something that we have a date that we're like, hey, this is going to be wrapped up by the end of the month or the end of the year, or this is going to ebb and flow and continue for the foreseeable future. So you have to manage that risk and be prepared to work through those types of things. So yeah, the question about when's it going to end, man, if we could answer that, we'd all be like on our own private island somewhere sitting in the sun with our toes in the sand. But I thought the concept of it being episodic was a good point.
Yeah, well, and I think even to add on to that, there's ways as employers continue to develop policies and figure out the way forward, there's ways to be proactive too on how, I mentioned cold and flu season is going to be a lot different. Employees are going to also have new expectations in regard to health and wellness. So we've seen a trend in that direction over the last several years to begin with about, employers offering more health benefits as far as gym memberships or ways for people to be proactively healthy, cut down on healthcare costs, have a healthier workforce that takes less sick time. And this, I think, is just going to even add to that conversation as far as, these things being seen as benefits to your workforce if you're able to provide them. So, really taking these things seriously and kind of, even thinking about how this can be a proactive positive in the future to have an even better workplace. We also talk about that in regard to telework. I mean, this has really catapulted telework for a lot of companies that were dragging their feet on whether they were going to allow telework. So there'll be a lot of updating of telework policies and operations as well.
Yeah, I mean, a lot of companies don't even have one policy about it. It's just something that happens, and it was used for meetings, and now it's a normal course of the day. So it'll be interesting to see how that evolves.
Yeah, and it's I've got a lot of clients that are calling me about that and just figuring out how to adapt, because it's both adapting from just a practical standpoint of how that's going to work, but also managerial and different pieces. I mean, a big thing that people aren't thinking about that I've talked to some clients about as well is alerting their employees that are teleworking about workers' compensation. So if your employee is moving a desk around to create his or her home workspace and hurts themselves, that's a workers' compensation claim. So there's a lot of pieces to the telework as well that employers and businesses and employees need to be thinking about and be aware of. Because I know I've got several clients who they may not send their employees back to a physical workspace because it's been working so well. So that's going to really, they have a lot to think about there. There's no shortage of things for businesses and employees to be thinking about right now, that's for sure.
Well, I'll leave you with one that happened to me. It's kind of humorous because there was no significant impact. I was on a call on my speakerphone in my office with a client. And at the same time, one of my sons was shooting a video of the dog playing in my office and posted it on Facebook. And I went and looked at it and I'm like, oh, this video ought to be good. And all I hear is the conversation between me and the client. I'm like, you have to take that down now.
Yeah.
We weren't talking about anything that was a problem, but maintaining confidentiality. So we sign confidentialities, NDAs with our clients. And it gets leaked on Facebook or something. And like I said, fortunately, there's no content in it that was of substance. But there's all kinds of crazy stuff we're all going to have to become more aware of and deal with and work through. But we'll get through it and we'll figure out a new way, and definitely with the help of people like you and Jon, helping your clients through it. The tough part's going to be for companies who are falling off the financial edge because of this issue, and are not going to, no matter how well intended they are to want to seek that advice and things, they're just not going to be able to fund it. And I think that there's an opportunity here for industry specific associations to help out some of those smaller firms by engaging as an association the right legal teams to help develop some industry specific things that are at least meet the minimum acceptable level. It may not be totally customized to that customer, but those types of associations and their role in helping the smaller businesses that have been, I mean, think about some of the restaurants that were doing great have gotten crushed financially, in smaller businesses and things like that they're going to need help from somebody to get this right, because they are wiped out financially by this event.
In many cases, doing something is better than doing nothing. So,
Yeah.
you know, to the extent that you can look to an industry-specific forum, as opposed to having no forum, that's better. It's a movement. You know, you do what you can do,
Sure.
but I think a lot of people are sort of paralyzed by fear. It's so overwhelming to them that they do nothing, which is a mistake.
Yeah. So, Jon and Sarah, how can people find your firm? How can they follow you guys? Jon, maybe you can talk about some of this content you guys are putting out, because it's awesome.
Sure. I found that a lot of content that was coming out of law firms and other professional service providers was either scary or distracting. It was, you know, here are the 37 things that can go wrong and how your business must act now on legal issues. Or alternatively, look at this picture of my cat, you know, hide behind your sofa and this will go away in a couple of weeks or a couple of months. I was trying to find a way that we can tell the stories of our clients and our colleagues and our neighbors who are doing things that are interesting or creative or inspiring, and helping them, you know, shine a flashlight on them, because a lot of them are so busy working on these initiatives that they can't invest in the marketing. So what we did just a few weeks ago was start a series called Inspiring Views from the Bright Side, trying to find people that are giving those points of light, the inspiring stories to help make us restore our faith in humanity, and to tell people you can pivot, you can revise your service offerings, you can help others, and it doesn't necessarily have to be a trade-off. You don't have to close down your business to do something else. So it's a 10-question survey that we have sent out to people saying, tell us about the inspiring things you're doing. It comes back, and then one of the lawyers at our firm does a quick Zoom call with them, and we send the Zoom call on, and we've been publishing. We published 5 this week. We have another 5 that are going up next week. So if Eric, you or anyone in your community know people that are doing things that are interesting, creative, inspiring, helpful to others, please let us know about them.
Absolutely.
Sarah, you can give out your phone number and email. Mine are on that slide, but you can find me at jwachs, JWACHS, at offitkurman.com. My phone number is 301-575-0302. I recently purchased the domain name inspiring-views.com, but it's not yet live. It will be very soon.
Yeah, and you can reach me at sarah.sawyer at offitkurman.com. So it's SARAH.Sawyer, SAWYER at offitkurman.com. If it helps you to remember my name, my brother's name is Tom Sawyer. My dad has
Great.
humor. And
for all the Rush fans.
My number is 410-209-6413. And I also wanted to point out that we've got a great coronavirus resources page on offitkurman.com. So that's also something you can check out. We've got all of our webinars and different pieces of content that we've been putting out there, blogs, some resources from outside of the firm as well. So definitely encourage you to check that out. And then also feel free to follow me on LinkedIn, connect with me on LinkedIn. And there's some good content that we've been putting out through LinkedIn and stuff as well. So please get in touch if you have any questions. Happy to help.
Yeah, I looked at the COVID-19. Jon had sent me the link to that a couple weeks ago, and your firm is really putting out some, I'll call it generous content, frankly, at no cost to the public. And I think that that's a great reflection of the culture of your firm, that you guys are contributing and helping people who are just trying to find their way through it. So, kudos to your firm and the leadership and just your overall culture. You guys are doing some pretty cool stuff. I love both of those things that you're doing.
Cool.
So
for companies that are trying to either get, process, or keep PPP loans, there is a CARES Act guide, which distills, 880 pages of law into a 40-page guide. And that's free, and I think it's pretty actionable. So feel free to look at that or send that to others.
Yeah, that's awesome. Thank you, Jon. Jon and Sarah, thank you so much for joining us. I learned a lot today, so I selfishly appreciate that you guys joined and shared content. And I think it'll be very helpful to our listeners. And for the listeners, thank you again for sharing the podcast with your friends and family. I put the links in for you to visit Jon and Sarah's firm. I encourage you to do so. Some amazing content, and obviously some great people to be doing what they're doing. So Jon, Sarah, thank you so much. You guys did an amazing job, and I learned a lot from you guys.
Thank you.
Thank you for having us.